Hello there and welcome. Another edition of the Disability Law Show. John Scholes here, and today pulling out the big guns, partners Sivan, Tumarkin, and Tamar. Agopian is here as well for the first time. Tamar has watched the show many times. She's on the radio show, but she said, Sivan, I want to take it for a spin one week. So she's on with us this week. A lot of stuff to cover, guys. We're going to get to three key questions about long-term disability and employment issues. Hugely important topic. That is on the way in just a bit. We'll get to some phone calls from our radio show, maybe a few emails. Anytime during the show, though, you'll want to write this down, a chance to reach out to either Sivan or Tamar, 1-855-821-5900 and help@disabilityrights.ca. Guys, lots to get through, but we always start off with a week that was a case of the day. Sivan, what do you got, pal?
John, another busy week, and by the way, welcome Tamar to the set. It's a real treat. She has a ton of experience with long-term disability claims. A partner at the firm, she handles claims across Ontario, BC, and Alberta. So it's really, really great to have you here.
Thank you.
I want to start off, John, with a case that you and I actually discussed earlier this week on one of our radio shows, which is about this individual who has been on long-term disability for 18 years. And the reason he emailed us is because apparently there's been a lot of turnover at his insurance company, and I believe there's a third adjuster or a fourth adjuster now on his claim, on his file, and they've said that they're doing a comprehensive review of his claim and that they're going to figure out whether or not he's entitled to ongoing benefits. Remember, he's been on LTD for 18 years. So for 18 years, he has not worked. He's disabled from working. And to boot, by the way, they said that his benefits will end at the end of the month. And so, of course, he is full of anxiety. He doesn't know what to do, very, very anxious, and you can understand that. Now, the first thing that jumps at me, and I'm sure that Tamar will probably agree here, is that after 18 years of being on long-term disability, for the insurance company to suddenly undertake a comprehensive review of your claim, I mean, there's a red flag there for me. Unless you're 65 years old and it's the end of your policy period, or unless you're lying to the insurance company and they have surveillance showing that you're going to work or doing something like that, it just makes zero sense to me that suddenly they're undertaking this review. So maybe it's an overzealous adjuster. Maybe there's something else that is happening internally within the insurance company. But the other thing that makes no sense here is that this person has been told that his payments are going to end at the end of the month. How can that be if they have not completed their comprehensive review? And so, John, I've gotten in touch with this individual. I've spoken with him. We're going to be able to help him here. It's completely unfair. And, you know, the lesson here to our viewers is this. If you have any questions, if you have any concerns with your LTD claim, if something's happening with your case, the adjuster is telling you to do something or is telling you that something needs to be done or anything like that, and you're uncomfortable with it, you need to reach out to us. If you reach out to us, we can talk to you in confidence about your case. We can advise you, give you your option, explain, you know, what to look out for, and it costs nothing. That's the other thing, right? I mean, we're here giving this information each and every week on this show, on our radio shows across the country, and we charge nothing for it. It's a public service. Of course, if you need us to help you, if you've been denied, if you've been cut off benefits, we can help you. But the key thing is to be empowered and get that information, and that, I can tell you, is one of those cases where it just makes zero sense to me. And if the insurance company really is stopping his payments at this point in time with zero reason to, especially when they haven't finished their comprehensive review, not only can we help him get his benefits, but we can go after this insurance company for what's called punitive damages, to punish the insurance company for their conduct.
Tamar, what do you think?
It's incredible to me that after all these years of working with insurance companies and now on the other side of the fence, that this sort of conduct continues to happen, John. And I can't agree more with Sivan in a situation like this. Once the insurance company is accepted for as long as they have, that your benefits are in approved mode, usually they put you on what's called long duration. This puts your claim into the zone where all they really need is a yearly update from you just to see where you're at from a health perspective, but certainly doesn't mean that they need to reevaluate whether you're going to meet the test of total disability under the policy. But I have seen, rarely, but I have seen, as Sivan has described, situations where you get a new adjuster and a new adjuster, and this overzealousness about taking these long duration claims and trying to fast track them to end them, to bring a closure to them. And why would you think they would do that? The sole reason, as we talk about on the show, is because if they can cut off the claim in some way or fashion, then they don't have to pay until age 65, which is typically the end of most of these disability policies. So I'm not certain about this individual who's reached out to us, whether he's been, how close he is to age 65, Sivan, but I think that is an important consideration, because think about it, if there's still 10, 15, 20 years left on that policy, a new adjuster is going to want to meet those expectations for the insurance company to try and see the closure of the claim, which is where you might see some of that extra adjudication and that effort to try and bring that claim to a close. I absolutely agree that it exposes the insurance company to a potential damages claim, and I think this is what we're here for, is have a conversation with us. Let's talk this through. Let's see where you're at, and let's talk about some options.
I think one of the interesting side benefits we talk about all the time, Sivan, is that if you guys end up going to bat for this guy, it's nice that the insurance company will no longer be making the phone calls to him. That part of the stressful situation is going to be gone, right?
Yeah, I mean that's a given, but most people don't know this.
Right.
Right. One of the first things that I hear from people is the anxiety that they get for having to speak with their insurance adjuster. Their blood pressure just jumps straight up anytime they get a phone call, an email, a letter. If we get involved, when we get involved, we are the ones standing between the person and the insurance company. And so the person can then focus on getting better. The family can focus on taking care of their family member. And that's absolutely key to understand. We take over all communications. We are the ones now applying pressure on the insurance company, not the other way around on the individual.
Again, anytime to reach out to Tamar, Sivan, member of their team, 1-855-821-5900. There's also a website that's constructed. Now, the other half of the firm and the other show we do is the Employment Law Show with Lior, but pocketemploymentlawyer.ca. It's about employment. It's in the title. But there's a nice section in there, Sivan, about disability law. Why is that?
It's a very good website, John. It was created a few years back, and you're absolutely right. It's called the Pocket Employment Lawyer. It deals with employment issues, but because we do both employment law and long-term disability law at the firm, across our offices, we do find that there is a lot of interplay between some of the issues. So individuals who are having issues with their employers oftentimes are on disability. They have issues also with their long-term disability providers. Or people who are on LTD, for example, now have issues with their employers, letting them go unjustifiably, illegally. And so we created this website. It's a free website. You go on it, you input a few key pieces of information about your situation, whether it's an employment issue or a disability issue, and you get answers quickly, directly from the program. At that point, at the end, if you want to reach out to any one of us, by all means, there's a button there you can click, and we will have a conversation with you. If you don't, close the browser. We will not know that you were there. But the reason why we're having, this discussion and why we have that LTD component as part of the website is because oftentimes people have questions about both issues, employment law and disability law.
Again, reaching out, pocketemploymentlawyer.ca. That's how you do it. Want to get to an email, you want to send along anytime. It'll either maybe appear on this show, maybe one of our radio shows across the country. help@disabilityrights.ca, right? Annabelle is first. I'm going to probably throw this one towards you. Tamar says, I've been on LTD for almost 2 years. After listening to your show, I'm aware that many people have their benefits cut off at this point. I was also just recently denied CPP disability. Will this affect my claim and ongoing benefits?
Great question.
Yep.
Thank you, Annabelle, for reaching out to us. And so the first thing I want to talk about is this idea of the claim coming to an end at the 2-year mark. We talk a lot about this on our show, and I want to dispel this notion right off the start. Most disability policies will pay you many years past the 2-year mark. It can go up to age 65, as we mentioned in our opening of our show. And so individuals will get this letter, and it'll say to them, your benefits are coming to an end because you've reached 2 years or 24 months of payments. And you have to understand and appreciate all that's happening typically at that stage is that the definition to continue to qualify for disability benefits is changing. Doesn't necessarily mean that you're not eligible or entitled to further disability benefits past that 2-year mark. And so I want Annabelle to understand and listen and hear from us that if her doctors are still supporting that she remains unable to work and that her health continues to prevent her from working, and typically past that 2-year mark, it'll mean in any scenario, in any setting, in any job for which she has the minimum requirements by way of education, training, and experience, then she is, in fact, entitled to disability benefits past that 2-year point. So I wanted to start out by dispelling that initial notion. The other part of this is that, why do many people get cut off after that point? that one's really obvious, John. It's because they don't really want to pay you past that point. And what the courts have said is that once they do pay you past that point, it's very difficult for the insurance company to stand up before a judge or a court and justify why they cut you off past that point. So they really do, you do get a lot of adjudication around that time frame and a lot of aggressiveness around trying to get that claim to end at that 2-year mark. And look, the fact that she was recently approved for CPP disability benefits, great. That's excellent because it is actually something totally different than long-term disability benefits in the sense that it's a government-supported plan. It has a test to qualify, a little bit different than what you would see in a disability policy. And it says, you know, do you have a severe and prolonged disability? And if you do, you will qualify for CPP disability. And in a situation like that, if your long-term disability benefits were to be cut off, your CPP benefits would continue beyond that point. You know, will it influence the disability insurer? It shouldn't. It could, but it shouldn't, in theory, influence whether or not you're getting CPP disability or not.
Do you get both? Meaning that if CPP gives you this amount and long-term gives you this amount, do you get both?
You can.
Wow.
Absolutely, you can. But the long-term disability insurer will take credit for the CPP disability, right? And so it's typically what it'll mean is that if you're, let's say, getting $3,000 a month for long-term disability, and now you start getting your government-supported CPP disability for $1,000 a month, the insurance company is going to pay you the shortfall, the $2,000 going forward.
So if the insurance company, Sivan, says, you know, you're not on CPP, you haven't applied yet, we're asking you to apply for CPP, do you have to? Should you? There's no bad scenario in doing that, is there?
You should, and a lot of people, when they contact me, they're very angry about that because they're saying, well, wait a second, I understand, I've read the policy, I've talked to the adjuster, I understand I'm not getting CPP on top of LTD.
Right.
It's not that if I'm getting $1,000 from LTD and $1,000 from CPP, then suddenly it's $2,000. They're deducting it. And so people are upset by that, except that if you don't apply for CPP disability, the insurance company, what they often do is they guesstimate or estimate how much it is that they think you should be getting from CPP disability and then reducing your monthly benefits accordingly.
Even if you're not getting CPP?
Even if you're not getting it, exactly. So really, you know, look, I mean, you can talk to 10 different disability lawyers and they may give you different opinions. My personal view is that there is no downside for applying for CPP disability. If you get denied, it doesn't mean that the insurance company is going to cut you off. In fact, if they use that to cut you off, in my view, you have a claim against them. So long as you cannot work, so long as your doctor supported you being off work, you can still go after them. And Tamar's right. If you get approved for CPP disability, it makes it that much more difficult for the insurance company to later on argue that you don't meet the test for disability. Because the government has now agreed that you are disabled, that you have a severe and prolonged disability. By the way, John, one of the websites that we have, that we often cite on our shows is ltdfaq.ca, long-term disability frequently asked questions. And we've created our website especially for people out there. It's a free website, and it has memos, very short memos in plain speak, okay, no legal terminology there, that explain certain things like CPP disability, common questions that we get. And so if you go there, you'll see it's a 2 or 3 page memo that you can just download really quickly, and it'll answer your questions, the most common questions about CPP disability and long-term disability law.
We will take a short break. On the other side, key things to know about long-term disability and employment issues. That is on the way. In the meantime, 1-855-821-5900. You want to send along an email, you can do that anytime. help@disabilityrights.ca. Stick around, we're coming back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, thank you so much for sticking around. Disability Law Show, John Scholes, partners Tamar, Agopian, of course, Sivan, Tumarkin here this week as well. Want to reach out with questions on your own after the show, more of a discreet, lengthy conversation. Phone numbers first, right? 1-855-821-5900. Email help@disabilityrights.ca. If you go to disabilityrights.ca, the website, there's a media tab. You can catch a radio show across the country that we do. They're archived as well, or you can catch them live each week. And contact is there too. Guys, 3 key questions about long-term disability and employment issues. Number 1, will you be denied LTD if your disability arises as a result of a workplace issue? How about that?
So the short answer, John, is it depends. All right, that's how when I first started law school, that's what the professor said. You want an A on the exam, every exam you just start with it depends. And we're not trying to be cute here. The reason why it depends is because it depends on the nature of your disability. And I'll explain this. Look, we have a partner that's often on the show, James Fireman, who likes to say that long-term disability insurance is not bad boss insurance. If you have issues with your workplace, if you are under stress because there's a toxic work environment, there's a bad boss, something's happening in there that's rendering you unable to work, the insurance company will say to you, potentially will say to you, look, if you have an issue at work, then go after them with an employment lawyer. Why are you coming to us? And in fact, we have lawyers on our team that deal with employment law. That's their specialty, and that's what they do. They go after these employers and these toxic work environments, claiming constructive dismissal, etc. So we can help people with these toxic work environments. But that's not the end of the analysis, and here's the reason why. Sometimes you have a situation where an individual has experienced this toxic environment or this whatever happened at work, whatever trauma happened at work, and now their condition, their psychological condition has become generalized. Right. So imagine a situation, John, that you are in that toxic work environment, and because of what's happened to you at work, you now can't work anywhere. It's no longer focused and localized to your specific work environment, working with me. Instead of that, you now can't work anywhere else. So it's a generalized condition. It may have originated with this particular workplace, but now it's much wider than that. In that situation, the insurance company then has to pay you because now your condition, the condition that disables you from working, is now generalized. The problem is that it's not that simple sometimes to figure out if it's this or if it's that. Is it an employment issue or is it a long-term disability issue, or if it's both, frankly. Sometimes it's both. That's the beauty and the uniqueness of our firm. That we have lawyers on both sides of the aisle, and some lawyers who actually do employment and disability law. And so it's important to understand that if you're having an issue at work, if you're having an issue with your insurance company that says we're not going to pay you, whichever way this falls on, we can help you. Sometimes it falls on both. Sometimes we go after the insurance company for denying the claim and then go after the employer for having let that happen.
Right.
The key thing is that we protect you no matter what happens, and that's really what you need to take out of this, that we can help you no matter what, with your employer and with your insurance company.
Tamar, number 2 is this. What happens if the insurance company cuts off the LTD benefits, but the employer doesn't take it back?
Well, and Sivan mentioned it already. We do have a number of lawyers that do both sides of our practice, and I am actually one of those lawyers. I do practice on both sides, and so I very often get this question, John. And my advice really is that the short answer is no. Your employer does have a duty to accommodate you and work with you and work with whatever health restrictions and limitations that your doctor says has to be put in place to allow you to get back to work. And really the guiding point is reasonableness, right? This is the guiding point in most of the work that we do. Has the employer made a reasonable effort to accommodate you back into the workplace? Are the restrictions and limitations that you have reasonable such that you can be accommodated back into the workplace? So it really is quite dependent on the type of disability. But otherwise, if the employer doesn't do what their duty and requirements are to try and facilitate that return to work when your doctors have given you the green light, then that could expose the employer to a potential claim as well. So again, I can't agree more with Sivan's point on the first topic. And the second topic really to this question is the key here, always follow your own medical advice. Whatever your doctor is saying in terms of facilitating, can you return back? If you can, what does that look like? Defer back to your own medical team, and then it is potentially on you to coordinate that return to work effort. And if you're getting resistance from your employer, you know where to call.
Again, we're talking about 3 key questions you need to know and ask about LTD when it refers to or when it relates to employment issues. And we had this exact question on the radio show last week, Sivan, that is, do LTD benefits end if you've been terminated by the company? Do they mesh?
No.
Right.
Yeah.
But this creates a lot of anxiety for
does.
people. Let me actually pivot away from that for a second. Oftentimes, you have people who are on long-term disability who are tracking what's happening with their workplace. You know, with COVID and everything else that happened, many companies have in fact closed. Look, if you are on long-term disability while your company is closing down, it doesn't matter vis-a-vis your LTD claim. You've been approved. You are now on LTD. The insurance company must continue to pay you unless you've reached the end of the policy, typically age 65, sometimes it's longer, or if you've breached a policy provision or something like that. But just the mere fact that your company closed down, that does not affect your LTD claim. And if your insurance company says otherwise, you're going to call us because we're going to help you. But I want to pivot away to something else. Sometimes you do have things happen with the employer. Maybe they're not closing down. Maybe they've been bought out. Maybe they've been letting you go, or they let you go, and there's severance. So sometimes, as a result of them closing down, or as a result of something happening beyond your control with your company, you may come into some money. And I know that wasn't the question, John, but that actually comes up quite often. Right. And so people ask, well, what do I do with the severance? Do I have to tell the insurance company? And we always say, look, we have to look at the insurance policy, at the policy that governs your LTD entitlements. And typically those policies contain provisions that say that the insurance company may be entitled to a certain credit, whether it's all of it or a portion of it, whatever that may be, for any severance you get, for anything that you get monetarily by way of income or something like income. And so it's important to understand that if you have questions, whether it's your company closing down or your company has been bought out or you've been let go, you see there is this interplay between employment law and long-term disability law, and that's why it's important to get that advice. And to get the advice not just from any law firm, because there are many long-term disability lawyers out there are many employment lawyers out there. There are very few law firms across the country that have a dual specialty the way we do. And I'm telling you, it's unique. We've come across cases on the employment and disability side where the lawyers handling either of those cases have made mistakes along the way because they didn't fully appreciate that interplay between those two areas of law. And so we're very, very cognizant. Our lawyers always talk to each other. And, you know, it's been a great, great experience helping people across the country.
Guys, does it make a difference if you're on LTD that your employer in the meantime goes from company A to company B for coverage? They switch insurers. Does that make a difference?
It shouldn't.
Right.
It shouldn't. And so there's some really clear guidelines for insurers about situations like this, John. And insurers like to play fast and loose with this sort of thing. But at the end of the day, if your employer changes the disability coverage provider, even your health provider for all the other coverages that you may have, including disability, it should not impact the claimant. Now, if we want to get into the details, you know, if, for example, you're on disability right now and you learn from a colleague that your employer is changing disability providers, but you're currently getting long-term disability benefits from company A, that continues. And that continues, very importantly, even if you return back to work and your health prevents you from continuing to work. If you had a prior claim, you've actually got to go back to company A, even if you've returned back to work, if you're typically within that window of 6 months of returning back to work. This is getting into the weeds a little bit about recurrence claims. Sivan, you'll know well about these kinds of situations, but I think it's important for individuals to understand that it's not upon them to be without coverage. That's the key.
Short break, guys. We'll get to a question from a website called mydisabilityquestions.com. During the break, you can check that out. Even throw a question in there. We might get to it in a future show. The number 1-855-821-5900 and help@disabilityrights.ca. Hang on. Coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Thanks for hanging around. A few minutes to go here. Disability Law Show, mydisabilityquestions.com. Free and anonymous website for you to use anytime to ask questions. Tamar, Sivan, member of their team, answer them. It's also a searchable database, right? That means you can type in your questions, see if one similar has been asked and answered in the past. It'll save you some time. If not, leave it there and we'll get to it. It might appear on a future show. In that regard, guys, Shane writes in, says, on my last phone call with my case manager, she asked for updates on my depression and anxiety and specifics on what I consider to be stressors. Her follow-up calls are increasing in frequency, despite her having all the updated medical information from my therapist. Can I refuse to continue communicating with her as I feel it is adding further stress and impacting my health?
So this is not uncommon. And, you know, it's difficult to assess from this email, John, whether or not the adjuster is doing this on purpose or not. Sometimes adjusters act in a certain way to try and shake off a claimant, right? Some people out there, in fact, many people out there, I suspect, will say, this is just too much. I already have these issues I'm dealing with. I don't need to deal with the insurance company. You know, to hell with the money. I can't do it.
Can't take it.
I can't take it. That's not the right approach. The right approach is to obviously write in or to call us and then we can advise you. And here's what I'll tell this person here, to Shane. The reality is that the adjuster is trying to seek information. Again, let's assume for a second that there's nothing nefarious here. The adjuster is not being difficult. They're just the type of adjuster that just wants a lot of information. But regardless, it's creating anxiety. I would tell Shane to, first of all, document the conversations, number one, and always email the adjuster subsequently after the conversations with just, you know, a factual accounting of what
Here's what we talked about.
Here's what we talked about.
Okay.
I would mention to my therapist and to my doctor on an ongoing basis, whenever it happens, that your anxiety shoots up, and this is what's happening, just so that there is a medical contemporaneous record along the way.
Good call.
And number two, in cases, more severe cases, I would say, where people really do feel that it's impacting their health in a bad way, I would actually tell you or tell Shane to communicate to the adjuster that you would like to communicate in writing. You would prefer not to do it by phone.
Nice.
Now, some adjusters are going to say, no, you can't do that, in which case my response back would be, show me where in the policy it says that I have to communicate with you by phone. The practical element here is that the adjuster may try and use that to cut off your benefits. Keep in mind, insurance companies cut off benefits all the time for the wrong reasons. That doesn't mean that they're allowed to do so. And when they do that, that's when we jump into action and we go after them. But, you know, my basic advice here is document, obviously, how you're feeling, talk to your therapist. Maybe even communicate to the adjuster that this is increasing your stress levels and actually communicate that in writing so that, again, we have contemporaneous records of you explaining to the adjuster that these frequent checkups are actually causing you anxiety. What's really important here is, though, if it goes too much, if you're becoming too stressed about it, then communicate to the adjuster that you want to communicate in writing. And if there is a problem, let us know, and then we can talk about your specific situation.
I know we've got only a minute left, but Tamar, can you ask for a new adjuster? Demand one?
You can, but I would start with all the advice that Sivan has already given,
Right.
and then take it to the next level, get to someone superior, try and work it through with a manager, and then see whether or not you can create some boundaries around when you communicate, how often you communicate with this adjuster, and see if things improve. But the courts have recognized if they exacerbate your condition, John, they're opening themselves up to a damages claim.
And always reach out to you guys so that doesn't do that.
Absolutely.
And then the communication stops, as we covered earlier in the show, right?
Absolutely.
So feel free to do that. We are done for another day. Appreciate all your contributions and tuning in for the last half hour. We'll do it all again. In the meantime, radio shows, go to disabilityrights.ca, the media tab. Email is help@disabilityrights.ca. And we mentioned mydisabilityquestions.com. I want to run through that again. It's free, it's anonymous, it's searchable. So your question, someone similar may be already there. You can simply read it. And Sivan mentioned at the top, ltdfaq.ca. That is a very simple website to use. There's boxes with topics, drop-down memos, plain speak, real easy. ltdfaq.ca. Use that anytime. And 1-855-821-5900. We'll catch you next time. Disability Law Show.